The fifth unit of our course concerns the common law tradition. It is important to begin with the history of common law in England, how common law was born in England, in order to understand its characteristics. On the screen you can see the outline, and in this video we are going to focus on the history of the common law system in England. England was part of the Roman Empire for 4 centuries, actually. Yet, Roman law did not have the same influence in England as it did in France, and Roman law was not received in England the way it was received in Germany. After the fall of the Roman Empire, England was invested by barbaric tribes such as the Jutes, the Angles, or the Saxons, hence the word Anglo-Saxon. These tribes were Christianized at the end of the 6th century, and it is an important event because Christianity did affect or did influence English law, especially in equity, as we shall see later on. Now, at the beginning of the second millennium after Christ, England was conquered by the Normans, a French people, led by William the Conqueror. Now, these Normans, they organized a new feudal system, and they did respect the existing customs of the locals. Actually, at the time of the Norman conquest, in England they had religious courts applying canonical law and local courts applying local customs. But this led to a fragmentation of the legal system. The only way these Normans, who spoke even different language than the locals, so the only way they saw fit to unify law in a progressive way was through the royal courts, was through a loyal judiciary, loyal with an L, and this loyal judiciary was the royal courts, royal with an R, royal courts. So these royal courts, who at the beginning comprised even itinerary judges, judges who traveled all along England to look into cases, these royal courts expanded in number, more chambers, and in prerogatives, more competence, more things they can look into, more cases they can look into. Now, the important thing when it came to these royal courts is that plaintiffs did not have direct access to them. And plaintiffs could not directly access judges. They had to address a complaint to the king, and the king will grant them a writ. What is a writ? A writ is a document then sent by the king or granted by the king containing instructions from the king to a royal officer, to an officer of the king. These orders could be a direct action, for instance, expulsion, to expel someone from a house or to seize a certain property. But they could also be an order to assign a judge to look into the case. So this writ granted by the king would order the royal officer to assign a judge to look into the case of the plaintiff. Now, what's important to know is these writs were mostly procedural forms, like categories of legal action, meaning that the plaintiff's demand had to correspond to one category of these writs, of these procedural forms, in order to be able to plead his case in front of the judge. If not, he would not have any right. On the screen you can see an example of a writ, of an actual writ. So these writs were procedural forms. In the judicial procedure, in the courts, you had first the professional judge. This judge assigned to look into the case. Now, this judge would was concerned by the procedure, so he did not decide the case. It was not him who would decide the case. He would control the procedure to make sure the correct procedure is being followed. But the decision to the case, the solution to the case was given by the jury. The jury composed of laypersons, of people who are not legal specialists. Then you had the lawyers of the parties. It has to be said that in the common law system, lawyers are held in a very high esteem, the same as the judge. And finally, you had the witnesses. The early common law system relied mostly on oral witnesses as a mode of proof. Then we can say that the birth of common law had to do with procedure in front of royal courts. And when we say procedure, we mean specifically the royal writs. These writs granted by the king to the plaintiffs. If you had no writ, you had no case. If your case could not fit into any category of existing writs, then also you had no case. That's why they used to say remedies precede rights. You have to have the remedy in order to get your right. يعني بشكل مختصر في أنواع كان من الدعاوى، يعني هالورث اللي بيعطيه الملك هو نوع من الدعاوى. في عدد معين من أنواع الدعاوى إذا أنا مطلبي ما بيدخل ضمن إحدى الأنواع الدعاوى ما بقدر أحصل على الحق. So it is quite obvious that the writ system had certain weaknesses. It was too formal, and the recognized number of writs or the recognized number of procedural forms was also limited, about 70 forms only. And the remedies granted by the royal courts were not always satisfactory. I will give an example. If my co-contractor did not perform his contractual duties, the royal courts could not order him to perform in nature. They could only order him to pay me reparation. And I would never obtain a performance in nature. تنفيذ العيني, l'exécution en nature. This was not allowed by the royal courts applying common law. That's just one example. So in all, for plaintiffs who could not get a writ or whose complaint did not fall into any recognized categories of writ, found an alternative. They would first ask the royal court to give them justice. The royal court would deny them that. So they would appeal to the king. The king would defer the file to would defer the case to the chancellor, and then the chancellor himself, or later on the court of chancery, would apply equity principles on the case, including new remedies. For instance, in the same example, in the case of non-performance of the other party in a contract, equity would allow an order of direct performance or performance in nature. The development of equity and the development of the court of chancery as an alternative to the royal courts created a certain competition between both courts. But the first reform at the beginning of the 17th century And then especially the 19th century reforms tried to find a solution, because in these reforms, the 19th century reforms, they merged both the royal courts and the court of chancery. So they merged these two courts, and all courts could apply either common law or equity. How do we know which law to apply to a certain case, whether equity or common law? It all depended on the nature of the case, because certain fields of law were dependent on common law, while others were regulated by the principles of, were submitted to the principles of equity. These same reforms simplified the procedure, so they eliminated the idea of writs, and they created a unified procedure. So claiming a right was no longer linked to the existence of a corresponding procedural form. If I have a right, I follow the unified procedure so I can get access to a fair trial. Given what we said, you can find out that the expression common law can mean many things. In the historical sense we just saw, common law meant the principles of law, the legal rules applied by royal courts in England, as opposed to equity. Equity being the rules of law applied by the court of chancery. Equity is insaf. But common law also has other meanings. In a very broad term, it could mean the legal system developed in England and exported elsewhere, such as England's ex-colonies. In this sense, we speak of a common law system as opposed to the continental or civil law or Romano-Germanic system. But the term common law can also mean the law made by judges as opposed to statute law or legislative acts. So in this sense, common law includes equity, because equity also is a judge-made law, the same as common law in the strict sense. But common law could also mean the law that is common to all of the kingdom, to all of England, and opposed to the local laws and customs of the barons. Now, in the context of comparative law, for instance, the title of this chapter is Common Law. What is meant is the fourth meaning here. Common law as a legal system. But in this video, we spoke of common law as opposed to equity. So on Monday, we are going to go through the characteristics of common law systems, and then we are going to jump to the American law to compare the law of the United States of America to the law of England, to the laws of England.